This is overview of guardianship in Alaska. So what is guardianship? It's the legal process where the court appoints someone to make personal, legal, and financial decisions for an incapacitated person. And the person who's appointed is the guardian, and the person who needs assistance is the ward. There's a definition of incapacitated, which is they lack the ability to receive and evaluate information or communicate decisions, so that they're unable to provide for their own shelter, food, clothing, medical care, etc., which puts them at the risk of serious physical injury or illness. So for health and safety reasons, they need someone to assist them with their basic health and safety needs. The guardianship restricts awards civil rights to the extent they're the guardian's given decision for the wards, and generally guardianships will take away the ward's right to make decisions about where they live, their medical care, what they do with their money. And so because of the interference with the person's rights, guardianship should be viewed as the last resort when all other methods of assisting or protecting the person have failed or been inadequate. So what are other methods of assisting people? So you may be able to find supports through the Aging and Disability Resource Centers, the ADRCs, that help people access supports and resources. Wellstone Soup Group is a resource connector that you're already connected with. And then the supported decision-making agreements that are going to be discussed later today are a really good alternative for high-functioning family members or people who need assistance, but don't need the level of a guardianship. Powers of attorney are a method that can be used if the person has contractual capacity and understands what they're signing. The drawback that some people run into is that there's no protection from poor decision making by the person who gives the power of attorney. So with a power of attorney, if your adult child gives you a power of attorney, they still have the ability to act independently and make decisions and do things. And all they're doing is giving you, through the power of attorney, the right to assist them with whatever activities they give you the power to assist them with. And that can, so it doesn't help you if they go to Best Buy and they buy something they shouldn't buy. You can't go in and undo it. Whereas if you're the guardian with conservatorship powers, they don't have the legal right to enter into a contract with Best Buy for buying a bunch of stuff, and you can go in and undo it. So that's really the basic difference, is whether they still have the right to act independently or not. And then conservatorship, which is the financial management piece. So this is for if someone needs only help with financial stuff, alternatives to a conservatorship can, if for Social Security benefits, can include representative payee status, setting up an ABLE account if the person became disabled before age 26, and setting up some kind of trust, and an asset trust, which can be a standalone trust, or they could join a pooled trust, which is run by nonprofits. So types of guardian: a full guardian gets all the powers, basically the same powers and duty that a parent has to a minor child. A partial or limited guardian is only responsible for specific matters that are laid out in the court order appointing the guardian. And then a conservator is only responsible to manage financial matters like income and assets. The guardians have a number of duties under the statute of what you become responsible for. And the main ones are noted here: housing in the least restrictive setting that protects the ward, care, comforts, and maintenance. So a guardian's responsible for making sure they have adequate food, clothing, transportation, assistive devices, everything that they need for day-to-day living. You're responsible for their health and safety and for protection of their legal rights. Let's see, there's a chat in here. Now my little go down. Okay. So there's a lot of responsibilities you have, but there's also limitations. I like to highlight these so that someone thinking of becoming a guardian knows that, you can't keep your guardian or your ward, which may be your adult child, from getting a driver's license. That's going to be up to the state to decide. They shouldn't have one. You can't stop them. And if the state gives it to them, then they have it. Marrying or divorcing, they can register to vote, cast ballots, and you can't, if they have a child, you can't consent to terminating their parental rights. You can't consent to certain medical procedures. You cannot withhold life-saving medical procedures unless it meets the conditions there. And this is more for elderly folks than young ones about prolonging the dying process. And you can't consent to experimental medical procedures. And so then as to responsibility for financial matters, you have to basically inventory all of their assets and make sure that they're properly insured. So if they have a car or a home, that they're not, those assets are insured. If they have debts, identify what those are. Same with where their income is from. See if they have benefits that they aren't drawing right now. Make sure their tax returns are done. Keep records of their income and expenses. And keep their property separate from your property at all times. And so we'll talk a little more about, but keeping accurate records of income and expenses, you have to file a report with the court annually that details all this information. And so it's very important to keep good records. And as to finances, you can be paid as a guardian only with a written court order. And if your adult child is going to live with you and pay room and board, again, that must be set in the guardianship order. It needs to be set out, the amount agreed on, and set out in writing in the court order. And if you need to modify the amount later, usually it would be an issue if SSI increases and then they're not able to spend money. So you need to charge them more rent to be able to keep them under the $2,000 resource limit. Then you would need to get the court to modify the order to allow you to increase the amount of rent that you're charging. And so who can be a guardian? So the statute lays out a preference. So if the person became incapacitated later in life, if they had previously nominated someone, that would be the person. Their spouse has the next priority. An adult child or parent is third priority. A relative that they've resided with for more than 6 months, it has the next priority. And then a friend or relative who has a sincere, longstanding interest in the welfare of the person, whether or not they've ever lived with them. I've had cases where that's been the case. There's no immediate family member, or the only family member is unable to serve. There could be a relative or friend who steps in. Private professional guardians are also available. And this has a link to the website where they are for all the Alaska's registered professional guardians. And then OPA, the Office of Public Advocacy, is the public guardian. And you notice they're last on the list because they do want to be the guardian of last resort. They want to have someone else be the guardian. If there's anyone else, part of it's just, they're overwhelmed with the number of cases that they have. So there are limitations that some people can't be the guardian if any of these 4 things are happening. They have, so basically a paid caregiver is not normally allowed to be the guardian, though that doesn't necessarily apply if it's a relative. If they're a creditor of the incapacitated person, or they have an interest that may conflict with the incapacitated person, or someone who works for anybody under number 1, 2, or 3 would also be disqualified. And so, but there is an exception for the spouse, the adult child, the parent, brother, or sister of the person if the court determines the conflict is not substantial and the appointment would clearly be in the best interest of the incapacitated person. So if Medicaid's paying you to provide services, it doesn't mean that you can't necessarily be the guardian. And so who will be the guardian? I just want to let you know here that the petitioner does not have to be the same person who will be appointed guardian. So you could nominate another family member or a private professional guardian to serve. So you could bring the petition, but you don't necessarily have to be the person who you want to have appointed to serve as a guardian. And the court's required to consider the respondent's preference. And I think I forgot to say the guardian is called, well, the ward is called a respondent while the petition's going on. And then after the court creates a guardianship, then the person is called the ward. So the guardian does not need to live in Alaska, but the ward does. So if you move outside and you have a guardianship over an adult child and they move with you, you have to transfer your guardianship to the new state. You don't keep it in Alaska. So the guardianship needs to be where the ward lives, or the person needing the guardianship lives. It doesn't matter where you live, it matters where they live. You can have 2 or more co-guardians, and unless the order allows them to act independently, the requirement is that they all have to sign whatever needs to be signed to make decisions. And then if the person has a spouse and they're the legal guardian, they may nominate a successor guardian in their wills. And then I made a note that sometimes co-guardians are added as parents age so that they have someone who can step in. Okay, so I see there's a question. Is transferring
we have a question.
I see that. Is
okay.
Transferring the guardianship from state to state a difficult process? It depends. There is a uniform transfer of guardianship statute now, but it only applies to other states who have adopted the uniform guardianship transfer statute also. So Alaska is one of those states. And so there are forms available on the court system website to initiate these transfers, but you have to, again, it has to be a state on the other end that has the parallel procedures. And basically you apply to have the guardianship transferred, you show you have the paperwork in Alaska, then they enter a temporary order there, and then the Alaska court has to come in. And so you file in the new state, and then you have to file in Alaska to get them to transfer it. It's relatively simple compared to other things, other ways of doing it, but it's not necessarily seamless. So, and part of it is it's kind of new. I went through one in the Valley with a client, and it was very complicated, but because they had never done one before. But in Anchorage, they apparently have done them and don't have any problem. Does that answer the question enough? Okay. let's see. All right, so I mentioned the court system self-help site, and so they have a whole section on guardianship and conservatorship that with the forms are online PDF fillable. If you don't have computer access or want to have a paper form, the local courthouses have the guardianship packets. You would be picking up a packet for adult guardianship, even if your child is a minor and they're turning 18, you're seeking to be their guardian when they become an adult. And so you need to have the adult guardianship packet, or the online, go to the adult guardianship forms section. And this has the details of how to get there. And then the guardianship petition process, there's a required packet of forms to start the process, the petition, the acceptance and oath, the letters and the order. And the, excuse me, as noted here, the person for whom the guardianship sought is called the respondent and will be the ward once the petition's granted. And then the second note about the person being nominated as guardian must sign the acceptance and oath. That goes back to what I mentioned before, that you can file a petition, but you may be wanting someone else to serve as guardian. But in that case, that person has to sign all the paperwork. You can sign the petition, but then they have to sign the other forms that the court requires in order to appoint them. And the petition is filed with the probate court, which is a subset of the superior court. The court appoints 3 people to assist the respondent, not you as a petitioner, and schedules the hearing. And the court will mail you as a petitioner the order for appointments and the notice of hearing. And then it's your responsibility to notify everybody that's an interested person, which is defined in the paperwork, and file the proof of notification with the court. And you'll note that certain people, specifically the respondent's parents and their spouse, if they have one, have to be notified by certified mail or process server. You have to be able to prove that those people got actual notice of the hearing if they're not the petitioners. Other family members, siblings and all, they could just be notified by regular mail. And so the 3 people that the court appoints to assist the respondent is they actually appoint an attorney for the respondent. They appoint a court visitor, and that person really does the bulk of the work. They basically run around and interview everybody identified in the petition that you've laid out, who has information about the person you're seeking guardianship for, so that they can verify that everybody agrees that guardianship's appropriate. And the expert is normally the respondent's physician, the person's physician, and the court visitor will get a report from them explaining the medical basis for the incapacity, because you have to document incapacity in order to get the guardianship. The report is supposed to be filed within 90 days of the date the petition is filed, and the petitioner or respondent may object to the report within 10 days. Historically, that hasn't always happened. I'm not sure how up to date they are with them now, but in the past, we'd get them the day before the hearing. But usually it was uncontested, so it wasn't a big deal. So the hearing itself has to be held within 120 days of filing. They are closed to the public. It's posted on the courthouse door. If there's, the hearings are posted with the initials of the respondent for privacy reasons. And then, like, if the next people are waiting for their hearing, they don't get to sit in and listen to your hearing. So it's just people related to the case that are allowed to be in. If you have somebody who doesn't want a guardianship, they have a lawyer that's appointed by the court, and there could be a jury trial on the question of incapacity. You can have a full-blown trial over whether or not a guardianship is needed, and the burden is on the petitioner to prove by clear and convincing evidence that the respondent is incapacitated and there are no adequate alternatives to a guardianship. And so if it is going to be contested, then that initial hearing that's held at 120 days is basically used to set on the trial on the guardianship. And there's nothing substantive because those hearings are scheduled for like 15 minutes or 30 minutes at the most. And so all they do is run through them quickly. If they're contested, then you're going to get kicked much further down the line on the calendar before you get a hearing. And so if it's not contested, then the judge goes over the visitor's report, sees if there's any updates, if there are any objections that weren't filed in writing before the hearing. They swear in the petitioner and basically have you run through the petition and affirm that everything in the petition is correct. And then the appointment is normally made right at the hearing. And then once that happens, you have 30 days to complete your education requirement, because if you're a family member being the guardian, you have to do an hour of education, which reading the court handbooks on the duties of a guardian. There's also video you can watch. There's a number of things you can go through to just get educated about what your job is as guardian. And you file a form saying you've done that. And you also have to file a guardianship plan, which again is a court form. Those are what the little bracketed things are, is a court form number. You have to file that plan that says what you plan to do, where if they're going to live with you, you plan to put them in a home or keep them where they are, or just lay out what you're going to do for all the things you're responsible for in terms of health, safety, housing, medical care, all of that. You just lay out your plan. And then within 30 days, 90 days, you have to file the guardianship implementation report, which is a really big report with the accounting of all their assets, and a lot more detailed information is required. So that's why they give you longer to work on that. And then you will have annual reports that need to be filed. There's a group called ASAGA, the Alaska State Association of Guardianship and Advocacy, which is a great resource for family guardians. And one of the services they've started providing is reminders for filing your annual report. And they'll send you a notice like 30 days ahead of time, and then I think a week ahead of time. And that's important because, as noted in the last bullet, if you don't do it, the court will issue an order to show cause why you should not be held in contempt. And if you still don't file it, you actually have to appear in front of the judge and explain why you're not filing the report. Because the report, is noted in the middle paragraphs, gives an overview of what's gone in the past year and provides a detailed accounting of what you've been doing with their income and assets. So the court wants to see those every year, make sure that you're still actively serving as guardian and you haven't disappeared, or if you've developed a health problem or something where you can't serve, then you need to have someone else step in and take care of things for the board, because they need to be cared for even if you're no longer able to do it. You need to get someone in to take care of them. So there are some additional forms. The court's made it easy for you to notify if you do change address. So you move from, the valley to the peninsula or something, you need to notify them. And it doesn't change the guardianship like if you move out of state, but they just need to know where to find you. It's possible they'll switch jurisdiction to the local court and maybe change the case number, but you need to keep them posted. And if you just move in town from one side of town to the other side of town, again, you have to notify them. Every 3 years, the court reappoints a court visitor to review and make sure everything's still running smoothly. And if they think there's some problems, they can recommend changes. But again, you don't have to wait for that 3-year review. If something happens and there's a change that needs to be made, either you or the board or anybody who's interested, so another family member or something, can request review of the guardianship at any time. And then at the board's death, there has to be a final guardianship report explaining what happened to all their assets. And then the last slide that's substantive here is just gives you links to some of the different resources that are available to help you as a family guardian with doing your job. Okay. So there was guardianship in a nutshell.